Your Honor, may I state something for the record?
You may briefly respond. Go ahead.
If all parties will recall, one of the detectives that is sitting right behind the prosecutor's desk right now, Detective Casey, just went through something similar with COVID and was not present for a couple of hearings. I don't know how long his protocol was. I can't speak to that situation. It's not my business, frankly. But he wasn't present in the courtroom, and I think that has relevancy due to probably him feeling the same way, not wanting to infect anyone else or put anyone else at risk. I don't see where there's any difference in my situation. Also, very briefly, for the record, I was able to make a phone call, phone call attempts, because they were attempts, this morning after I came from getting the test because I raised the issue. I said, since I know that I'm going on this protocol and I'm already out of my cell, can I take this opportunity to try to notify my family of what's going on? That's why there were so many attempts, because I wasn't able to reach my mother, who pretty much has access to my kids. If I need to get some information to my children, she's the one that is in charge of all that. So I just wanted to state that for the record.
Thank you, Mr. Brooks. Well, the court has heard from Mr. Brooks. The court has heard from the jail administrator. The DA has provided some additional information as officer of the court. Let me address Mr. Brooks' motion to adjourn. He filed an inmate communication form earlier today, raising this issue. He is on a protocol. He is not tested positive. He provided information today that he is fully vaccinated, that he'd been telling officers for days that he had not been feeling well. We do not have the test results today. He was offered a rapid test and refused. He reports symptoms of fatigue and that he can't taste. He also indicated it was a few days ago over the weekend that he started experiencing these symptoms. Now, during his time here today, Mr. Brooks, despite the disruptions, has been very clear, coherent. He has asked questions. He's made objections. I know he might not like the word argument, but that's a word that we use in the adversarial system when the court asks the parties for their positions on certain issues. We call it legal arguments, or arguments for short. Doesn't mean or have any connotation that it's unruly or disruptive or a disagreement. It's just the word that we use in the legal system. He was able to articulate his positions to the court. He at times appeared animated. He appeared, again, to understand what the court's either questions that the court was posing to him or information the court was providing to him. He clearly was able to Mr. Brooks, please don't interrupt me or I will mute you. He was able to follow the questioning and answering process with the one witness who is here today. I appreciate that he clarified that he was not making this request due to trial prep or access to material issues, but it was really related to his health and safety concerns. At this point, there's insufficient information on the record to find that his concerns are anything more than speculative. And given my observations here in court today, he is very able to assist his In his own defense, he's able to present arguments, etc. I've already noted. We are able to accommodate the health and safety concerns in this courtroom. We confirmed that where he sits at the table, if he's in this courtroom, there is no one around him who would be within 6 feet. That is an important consideration that has been one of the topics of guidance from the CDC, certainly one of the, or part of the guidance we have received from the county. The most recent county protocol talks about isolation for 5 days. Clearly, if he had the onset of symptoms over the weekend, which is what he reported, and he has not had any escalation in those symptoms, as has been demonstrated by his ability to participate in this hearing. The court will find that there are no present health and safety concerns other than what I've noted with the 6 feet and social distancing. I'm not going to adjourn this trial. I'd also put on the record that he has not been denied access to materials. He has full access even with this protocol. He has had access even to the phone. There's been what's been referenced by both the state and Mr. Brooks about attempted phone calls. I'm not so concerned about whether phone calls go through. It's the fact that he's been given access. Whether he connects with someone is not the issue. I'm also concerned about the fact that he would not answer the court's question directly about whether he would take a rapid test. To me, his credibility is at issue with that. If he were truly concerned about his own health and safety, he would want to know immediately, and he repeatedly would not answer that question and instead wanted to debate about what test was provided to him and why perhaps it was not. All right, you're interrupting me. I'm going to mute you. So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic, given the information that this court, and once again, on the record before me, there is nothing to suggest that he is actively being impacted by COVID-19, and that any health and safety concerns he has for his own safety can again, be met. The jail's able to get him here. The jail, of course, is responsible for his medical care. We can keep him 6 feet away from any other person. Obviously, if he's removed to the other courtroom, that provides a greater buffer as well. And